Greetings, y'all. My name is Tracy Stallings, and I'm an adjuster here at Alicomp, and I've been here for about 9 years.
My name is Lucretia Daniel, and I have been with Alicomp for 5 years this year.
And we are here to try to give you a claims crash course on the very beginning of an injury all the way to how we handle a claim. And we hope that you find this information to be helpful.
With the disclaimers, we are not doctors.
And we are definitely not lawyers.
And sometimes the answer is,
I don't know. This is a form that you need to get used to looking at for workers' comp.
What starts a claim? Not the injury. The injury is why you need to file a claim.
And it's not the notification, because this is the reason you need to file the claim.
The claim does not start until you file this report to your insured. If you do not have a blank first report, you can find it in multiple places. It's on the Alicomp website. It's also found on the Alabama Department of Labor Work Comp's website. And you can always call or email one of your favorite adjusters.
We are here to help. That is what we're here for. So what is the first report? The first report is the document that's required by the state of Alabama in order to file a claim. That sounds so simple, but it's actually fairly complicated. This first report must always be filed on a new, specific, and separate injury.
If an employee has a left knee claim and claims right knee pain, that's a new claim. But if there are 4 months out of a left knee claim and they come and tell you that their left knee is hurting again, typically they will file the same claim. Now, if they're saying that they fell and hurt their left knee again, that's likely a new injury.
And it's going to be your responsibility to complete this timely. You need to file it with us as soon as possible, preferably the same day if at all possible. Because there's 3 options of types of claims to be filed. You have your record only, your medical only, and your lost time.
Notice. What constitutes notice? Any type of firsthand knowledge to management. This could be to a supervisor, to HR, to anyone who's over the injured employee.
The caveat to that is a lot of times bigger employers will have leadmen or foremen. Those would be considered over the employee. That would be somebody the employee would see as a position of authority. So even if it's somebody that's not quite management staff per se, it is still somebody that the employee would see as over them. So even anybody that seems like it would be a position of authority over another person would be constituted as notice.
So your role is to pretty much train your supervisors on how to report to the proper person, and giving those employees knowledge of who to go to report if they have an injury. It's very important that the first report of injury and notice is provided to someone who is in charge so that you guys can get that first report of injury over to Alicomp.
An option that you could do is put posters up or notices up, just a piece of paper printed out all over the plant that says, in case of injury, report to such and such immediately, or detail to this person. Have some kind of set policy that everybody knows.
And just keep in mind, once you are placed on notice by that employee, you are bearing the entire responsibility until that first report of injury is submitted into Alicomp. That's why we reiterate it's so important that the first report of injury is filed timely to us so that we can go ahead and take care of that for you guys.
Because the statute places the responsibility on the employee to report it timely, but then puts the onus on you as the employer to report it to us.
Between notice and filing, there's a complete claims guide on our website at alicomp.com. Under the claims option, there are claims forms. These include the claims guide. It also includes a treatment authorization form, a sample medical protocol, and a lot more information that you may need in order to go ahead and get that first report turned into us.
Because the important thing is that you follow the company protocol. If you do not have that protocol yet, we are more than happy to help you set something up. You can just call over to the claims department. Any adjuster can help you, because you've got to be able to follow a certain consistent pattern. You always need to determine that best course of medical action. Is it serious that they need to go straight to the emergency room? Do they need an ambulance? Or is it just first aid? Or maybe they can wait and go to the general occupational clinic when there's an appointment available. Possibly they need to go into urgent care. You need to be able to have some critical thinking and know what protocol you need to institute. If it's very serious, you do not want to take them to just a regular doctor. You want to go ahead and send them to the emergency room. So you need to make sure you're directing that appropriate care.
And just make sure maybe you have this posted or your supervisors are aware of where the employees need to go. So if you have a specific AFC or urgent care in the area, go ahead and post that information so that when an emergency happens, everyone is on the same page and that they know where to send that employee, just in case you're not. If you're the person that's responsible, just make sure the person that is there, that's on staff 24 hours a day, everyone knows where that employee should go if there's an accident.
After you've taken care of the emergency issue and you've taken care of the immediate issue of the injury, then you're going to need to start and complete an investigation. There are some forms to fill out. Sometimes in-house companies will have their own special forms and supervisor reports, witness statements. Make sure that your people know what your procedure is and that you get any statements that you can possibly get. You're going to want witnesses. You're going to want the supervisor. You're going to want the employees if you can. So start and work on completing your investigation.
And also, if there's any video surveillance or any information that you can provide to us, that helps us out tremendously when we're completing our investigation. So just make sure that any information that you receive as a part of your investigation, that you're providing that information to us as well. And just always remember, we are here to help you. If you have any questions, please feel free to reach out to us.
And we ask that y'all do not make the final decision. That's why we are here. We are here for your protection. We have certain procedures that we have to follow. We know the state rules and regulations. We know the codes, the state codes, the administrative codes, case law that has changed, and we have backup methods and certain ways that we can determine compensability. If we do it, we can protect you. If you do it, we have no protection that we can use because that could open you up to outrage. So please don't make the final decision. If you're in any kind of doubt of whether something is workers' comp or not, call us, file the report, let us handle it. We're here to back you up.
Yeah, just let us, just to reiterate and touch on that, just consult with your carrier before proceeding, past immediate medical treatment and investigation. Also, like I said before, provide us with any type of results of your investigation and let us assist you. How to fill out the first report completely. When filling out a first report, make sure that you are completing the first report to its entirety. Make sure that first report of injury has the employee's complete name, their social, their date of birth, their correct address and contact information, because a lot of times we get the first report of injury and it has a telephone number on there where the employee probably had 4 or 5 years ago and we can't reach out to them. So please, when you're filling out that first report of injury, make sure that you're filling it out to its entirety.
Because if you don't, the first thing you're going to get is a call back from one of the assistants that state, we need this additional information. We can't even put it into the computer system until it's complete. The state requires that we give electronic reporting to them, and without that information, we can't even finish putting it in the computer, much less get it assigned. So we can't stress enough that we need that first report to be as complete as possible.
And there are multiple ways that you can get that first report of injury over to us. You can send it to our website. That website is claimsfirstreport@alicompins.com, or you have the option to fax it to area code 334-215-8480, or you can submit it through the portal. If you don't have access to the portal, Amanda Starling, she will be happy to help you get set up for the portal, and you can reach her at that same contact number, 334-215-8234.
And I'm going to caution you, word that report carefully. These are discoverable. If we get subpoenaed, we're going to have to send those in. One of the first things that we ever get on the letter of representation from a plaintiff attorney is a copy of that first report, and we're required to send it over. So you want to be very careful on how you word that, because other people are going to be able to see that document besides just you and us. So I just want to put that little caveat out there. We also can send it to the doctors and vendors, providers, therapists, etc., because that has all the demographics on how to reach their patients. And that also lets them know what to be treating. So again, just kind of be very cautious of that. And if you've got any questions or concerns, we're going to stress this over and over. Call us. That's what we're here for.
I know that the notice emphasis is annoying, but it is one of the top complications that we see. We have no legal standing to help you until that document is complete and in our hands. In the cases of emergency, call us and let us know. We can assist you in escalating a first report and its assignment to an adjuster. So please, like I said, we can't stress it enough. Please get the first report of injury over to us as soon as the accident happens, so that we can kind of help you out and facilitate as much as possible and take that burden off of you.
And make sure you have that medical protocol in place. You need to be able to respond immediately. You're not going to have time to make a decision after somebody's been injured. So you need to go ahead and have an initial authorized treating physician or the authorized emergency room in that kind of situation. And again, if something happens and you need some quick advice, again, we're here 8 to 4:30, Monday through Friday. Give us a call.
And communication is key. You have to make sure that you're keeping in contact once that first report is assigned, once that claim is assigned to adjuster. Make sure you are keeping in contact with your adjuster. We will make sure that you have our contact information once the claim is assigned. We'll either reach out to you by telephone or by email so that you have our contact information just in case you need anything from us. Like I said, communication is key. So make sure you're keeping in contact with your adjuster once that a claim is assigned to an adjuster.
And another thing we keep stressing is filing the report ASAP. It is in the policy, in the participation agreement that you signed. It's in the state statute that it has to be signed or reported immediately. So again, that is something very urgent and very careful. The fastest we get to working on it, the faster we can get somebody taken care of. And it really does cut down on complications in the long run.
Important things that you do not need to do. Like we said, please do not make any judgments. If you feel that a claim is not compensable, let us do that. Let us make that decision. And again, file that first report timely so that we have time to investigate. Do not make authorizations alone. Call us if the doctor's office is saying, hey, this person needs to be to get an MRI or imaging or physical therapy. Make sure that you're contacting us so that we can get that set up for you.
Because even without the first report, we could go ahead and kind of guide you on what to do until we can get the first report. So somebody has fallen and hit their head. The doctor wants an immediate CT scan. We can tell you how better to set that up. Go to such and such. We do have PPOs. We have discounts. We have contracted rates with some of the facilities. We can get you to a good and proper facility in a timely manner, and we can help you do that even if you haven't filed the first report. You would have to make the authorization, but we can kind of guide you in that. But whatever you do not fail to act. When somebody is injured, you have to respond. You can't wait and say, we'll do this later. You can't wait and say, well, let's wait until we find out this information. You have to start acting. You have to start going immediately. So after the first report, then who's going to do what? First, the roles in the claim, the employer. Your job is to maintain communication with the employee and with the adjuster.
The adjuster, we handle the claim. We're going to make sure that we're reaching out to the physicians after the patient and your employee is seen. We're going to reach out to the physician's office to make sure that we're getting your work status slips to let you know that employee's work status if they're able to return back to work. And we'll communicate with you to see if you're able to accommodate the restrictions, if there are any restrictions provided by that physician.
And we'll kind of go more in that in specifics in just a little bit. And then, so in the meantime, when we're doing that, the doctor's going to be treating the patient, and it's going to be the authorized treating physician. sending them to different doctors, we can't do that. Once the doctor has been chosen and your protocol has been followed, there's no hopping back and forth from doctors. We can't change the doctors, they can't change the doctors. And the doctors are going to be there to treat the patient, and we're going to be following whatever the doctor recommends.
We do have case managers. This will be for your more complicated medical issues where we need ears and eyes there at the doctor's office. A lot of times when you have an employee that has to go out for surgery, a case manager is there to be the patient's advocate, that employee's advocate, to communicate with the physician and get that information back to us so that we're able to proceed with medical treatment as directed by the medical physician.
And I specifically made it where stressing that lawyers handle litigation. The reason I use that specific term is we as adjusters are trained to do some of the legalities without the interference or the need for a necessity for an attorney. We can handle settlement negotiations. We can handle a lot of stuff that pops up, questions, concerns, communication issues. So until it's actually in litigation and a suit has been filed, the adjusters can handle a lot of it flat out from the beginning.
Just to touch back on that before we move on, just because an employee goes out and obtains an attorney does not mean that we will hire an attorney as well. We will assign an attorney to the file. So just keep that in mind. Just because if that employee gets we get a letter of representation for that employee, we will not automatically just assign an attorney to the file.
Things to watch for during a claim. Red flags. We've all seen them. We all know them. I put a few up here on the slide so you have something to go by. But red flags are not an immediate denial. You have to have proof. These are just things that tell us we might need to look a little closer. Maybe there's something we should be able to dig for. Maybe we should check a Facebook page. These are just things to let us know you need a little extra attention.
And if you hear anything, employees, they talk. So if you hear anything, please keep us in the loop of what's going on so that we can investigate more thoroughly. But again, don't make assumptions. We have to have proof. So just kind of let us do the investigation more thoroughly if you do happen to hear anything. So what does the adjuster do? What will happen when we get the first report of injury? When the claim is set up, we will do 3-point contact. We will first reach out to you, the employer, and then we will reach out to the employee and then to the medical physician, the doctor, whoever the employee has treated with. We will also get the plan of care so that everyone is on the same page. Like I discussed before, we will get that employee's work status so that we can kind of determine if you have any light duty, if any is assigned for that employee to return back to work.
And part of the investigation is determine compensability. Are we going to accept this claim, or are we going to deny it, or even deny it in part? And yes, to clarify, there is an in part. We can deny the indemnity, which is the compensation, while accepting medicals. The statute lays out some rules and specific issues that we need to follow. If someone has a positive drug screen, for example, a lot of times that can fall under a presumptive positive, and that means that we can deny the indemnity because the way the statute is written. It has to be in certain criteria. That's not an end-all be-all. That's just an example of what we can do. Sometimes if we can show that a claim was done willfully, if the injury was done in a way that was intentional, we can deny the claim on that. But the vast majority of claims that we get are compensable and they are accepted. Denials are very rare and based on very specific criteria.
Again, if a claim is denied, please let us let Alicomp your adjuster take care of that. We will handle that on your behalf. So please do not deny a claim or presume that the claim is not compensable on your own.
So once the claim is accepted, we'll handle the medical care and we'll handle the indemnity. Again, communication is key. We need to know when you've stopped paying an employee. We need to know when you started paying them again. We need to know if you continued salary or if you're paying them to go to the doctor or paying them not paying them to go to the doctor. We also make sure that we coordinate the appointments and the medical care. We authorize and set up any kind of other appointments such as MRIs, CTs, physical therapy. So basically, we coordinate all the benefits, medical and compensational.
What happens during the claim? We do have the ability to decline tests if they appear unnecessary and unrelated. However, we must have strong grounds to do so. You have to keep in mind that the doctor, they rule the claim. So we can't just call up to the doctor's office and say, hey, we don't feel that, what you requested is something that this employee needs. We can't do that. The test may be unrelated or maybe outside the national guideline, but the state lays out a level of denial. We cannot deny medical treatment without a peer review or another physician. And an employee can request a panel of 4 when they are dissatisfied with the treating physician. Normally, we will request that in writing from the employee if they're unsatisfied with the treatment that they're receiving from the physician. It's not uncommon for the employee to request a panel of 4. This is law. We must provide them with one unless there is a legal standing that no further treatment is due, either by a physician's note or by legal review.
Also, they must be allowed time to go to the appointments. You have to allow them time. We try as possible to work around work schedules, but that's not often feasible, especially since doctors have limited schedules. It's very difficult to get them in with specialists, orthopedics of sorts. So we need to be able to work around that. And like I mentioned earlier, if they're not paid for that time missed, you need to let us know, because if they get up to their waiting period time, then they're going to be doing compensation even to leave for the doctor's office. So we need to make sure that we communicate with what they're doing and how they're going to the doctor. And if they request, they must be allowed to have a private exam. I know there are some employers that will drive their employees to the doctor and help them with their appointments, and that's fine. But if the employee asks for it to be private, then you must let him by law.
And also the doctors, they do determine the work status. I know a lot of employees will reach out and say, well, why did this physician place this employee off work? Can they come back to work? We have no legal standing in making them return back to work if the doctor has placed them off work status or provided them with light duty restrictions.
Going into more depth of the work status, full duty is just what it says. Full duty, they can work and do whatever they need to do. Doesn't matter what position they're in, they can do full duty.
Light duty is just that they'll be allowed to return back to work under the restrictions that the physician feels that the employee is safely able to return back to work under. I know a lot of employers do provide light duty at restricted duty pay. You do have that option, and again, if you have reduced that employee's wages under the restricted duty pay, please let us know, because we will need a copy of their check stub after their payment so that we can issue any payment that's due to them.
That is done, it's called temporary partial disability, and basically we take what they did make and we subtract it from what they should have made through their average weekly wage, and we multiply that by the comp rate. So there is a way that you can pay them a light duty restriction, whether you kind of cut their hours or cut their pay because of the position. We can work with that. So again, communication, you have to let us know. And quite frankly, we are aware that sometimes employees don't want to return to work on light duty. They complain of pain, they're having issues, they don't want to do the light duty, they don't like the position. We get that. If they do not return to work when released, then we do not pay them. They're not excused from work. They must be excused by the doctor in order to be either on light duty or to be off completely.
And in some cases, the physician will provide permanent restrictions. We will reach out to you and let you know what those permanent restrictions are, and it is your responsibility to get back with us to let us know if you're able to accommodate the permanent restrictions that the physician has provided.
Now, to go further into the claimant's pay, we handle the pay, and it's all going to be based on that work status. There's temporary total and temporary partial. Temporary partial is what we kind of just covered. That is if somebody is at reduced hours or reduced pay. Temporary total is they're completely off work. Maybe you can't accommodate the light duty. We get that, and we can work with that. So if they are on something like no use of both hands, and there's very little they're going to be able to do, so you're going to leave them at home, we will cover that as TTD. Just because there are restrictions, if you can't accommodate that, doesn't mean that you have to bring them back in, nor does it mean that there are restrictions, so therefore they don't get paid. We just go with what you can and cannot do. If you can't do it, you can't do it, and they're off work. And again, it has to be excused versus unexcused. If you say they need to come to work, that you do have a light duty position, and they opt not to, then that's unexcused. If they're on light duty and you cannot accommodate, then that would be excused.
Again, communication is key. If that employee is off work and they're due TTD or TPD, make sure that you have sent the 52-week wage statement over to your adjuster so that they are getting those checks out to the employee, because there's a state mandated time frame on this that we have to issue pay to the employee, and that's 30 days. After that 30 days, we will have to pay a 15% penalty if those wages are not issued out to the employee. And you have to think about it. The longer that employee waits on a check, the angrier they become, and it then turns into possibly some legal issues if we are not issuing those wages out to the employee in a timely frame.
And it also changes the employee's view of the claim. It sets an aggressive, antagonistic tone, and it makes it harder for the communication to happen. The quicker that we can do things, the quicker that we can work together, the quicker we can all get through this, and the happier people will be. It gets smoother and more calm and a lot more effective.
How does the claim end?
I'll be quite frank. Sometimes medical treatment will never end. It will be a serious issue, a catastrophic injury. Sometimes medicals are going to be open for life. The state of Alabama allows that. There is no statute of limitations on medical treatment. And depending on the injury, sometimes it's just never going to end.
But in most cases, the employees do return to work. Most of them at full duty, some at permanent restrictions. And like I said, you will have to make the determination if the physician provides permanent restrictions to the employee, if you're able to accommodate and bring them back to work, of course, safely.
Every claim is going to reach an MMI, though, and that's your maximum medical improvement. And it's just what it says. They are at their maximum. They are as good as they're going to get. They've healed to their full potential. If they were not returned to full duty, and in some rare cases, even if they were, they might still have an impairment. And an impairment leads to a permanent partial impairment, it's your PPI. And you might see us use a term IR for impairment rating. This is set through a guideline set forth by the state and usually done by a therapist or a physician to measure loss of strength, loss of flexion, and they put these into the formulas and give a permanent partial impairment to that body part. We use that impairment to begin settlement proceedings. Because it goes into a formula that is also set for the state, each body part is assigned a different level, and that is used to calculate the settlement.
And again, we will take care of that. If for some reason that employee was not issued any wages, we will request a wage statement from you so that we can get their salary, so that we can come up with the formula and compare the formula with the salary in order to get that settlement.
So basically, to summarize, at the responsibility at the end, it is the employer and the employee that need to get together to determine the return to work and the position and the pay, and it is our responsibility to do the final settlements. At times, we can close medicals depending on the injury, so we might include that in the settlement. Sometimes we can't. But the settlements will be with our responsibility, and we will keep you informed of what's going on.
Litigation. We do try to avoid litigation, but sometimes it's inevitable. Remember, everything you do in a claim could be presented in front of a judge someday. So, again, like Tracy stated before, please be sure to word everything very, very carefully, because it can resurface and it could come back to bite you someday. So we really like to handle things ethically. Make sure that you're not putting anything in writing that you do not want to come in front of a judge, become in front of a judge one day.
Pretty much think of you're being watched no matter what, because at any point this could come back. So do it properly, do it carefully, and we've said this before and we're going to say it some more. If there's any kind of questions, call us. If you've got a concern, call us. If you don't know the proper way, call us. If it's something that we can't help with, maybe it's something regarding a HR dispute or OSHA or some other issue, we can at least direct you to who you need to call, even if we are not the ones with the answers. Because at the very beginning, the disclaimer, sometimes our answers are we don't know, but either we can find out or we can tell you who can.
And just keep in mind, we provide defense for workers' compensation only. If you happen to get a wrongful term or negligence, this will be something separate that will have to be handled by your corporate attorney.
So the general rule of thumb, always proceed carefully and wisely and pretend that someone is watching you. So pretty much the recap. We've gone through the very beginning all the way to the wrapping it up at the end, with and without litigation. And the one thing we stressed throughout the thing, besides notice, was always ask your adjuster for assistance. We are here. That is what we are here for. That is what we are here to do. You can pick a favorite adjuster, call them, email them. If you have any questions, call the regular number, 334-215-8234. Ask for anyone in the claims department.
And we're here to help. I mean, like Tracy said before, sometimes we may not know what the answer is, but we can definitely get an answer for you. So please feel free to reach out to us if you have any questions, any concerns. Any adjuster should be able to help you. Any supervisor here should be able to help you with any questions that you may have.
Normally at this time, we'd be in front of people and we'd have questions and answers. Unfortunately, we can't do that. We're sorry to be missing y'all in person. But if you have any questions or concerns, you know how to reach us. Please call us. Again, we can't help you if we don't know about it, and we are here to step you through. We're here to make sure that anything that you need done is done. We appreciate your time and attention. Thank you so much.